Hello and welcome. My name is Peter Afrasiabi. I am an intellectual property litigator at the law firm of One LLP with offices in Newport Beach and Los Angeles, California. My practice focuses on copyright, right of publicity, trademark, and related privacy torts. I also teach as an adjunct at the University of California Irvine School of Law, where I teach a Ninth Circuit Appeals litigation clinic with my students, as well as an advocacy and persuasion course. I have taught advocacy at the National Institute of Trial Advocacy and taught advocacy to new barristers at Oxford University in England. But keep in mind, all of the views expressed in this video are mine and mine alone, and are not the views of my law firm, the university, or any other academic institution or entity I work with. Today's program asks the question, is Rome burning? Is our democracy dying? We will answer these questions with specific analysis of the law of Electoral College with a pit stop on the law of secession. And all of this is with an interview I have done, and you will see, of the Dean of Berkeley Law School, Erwin Chemerinsky, also the author of a great new book asking about the death of democracy via the legal system. Now, substantively, we look at the law of the Electoral College stemming from our Curious Lawyer series. But the twist is that we will also address the state of the law and the problems it creates within the legal system by looking at Erwin Chemerinsky's 2024 law book, No Democracy Lasts Forever. With the discussion of the Electoral College bargain, Supreme Court law on the Electoral College, and an interview with the Dean of Berkeley, Erwin Chemerinsky, you will leave here more curious than when you entered, I promise you. And we will start with a snippet of the interview so you can understand the book and conversation we will have in this CLE today. Sort of a fun sneak peek we give you now out of the gate of the interview that we will play at various points throughout the program. And stay to the end to get all of it.
Well, thank you for being here with us today to talk about your really fantastic book, I thought at least, in terms of, where our democracy is going. And I thought maybe we could start by discussing, at least as it relates to the Electoral College, what's the story of your book, the thesis advanced, and why ultimately did you write this book now?
Thank you so much for inviting me to have the conversation. After 2020 election and after the insurrection on January 6th, I realized that I was deeply concerned about the future of American democracy and wanted to think through what was the nature of the crisis, what caused it, and what could do about it. I mean, I saw a country where people had lost faith in their government. The Pew Research Institute does a survey every year of confidence in the federal government. They started in the 1950s. The high water mark was in 1964, 77%. The last time they did the survey, it was at 20%. Congress approval rating is at 16%. The Supreme Court has its lowest approval rating in history. The country is more politically polarized than it's been since Reconstruction. And the thesis of the book is that to a large extent, the current constitutional crisis is a reflection of choices that were made in 1787. They may have been necessary choices to get the Constitution adopted, but because of recent developments, they become even more problematic. You identify one of these, the Electoral College. The Electoral College was a terrible way to choose the president in 1787. It was based on a distrust of the people. Alexander Hamilton said in the Federalist Papers that we need the elites, not the masses, to choose the president. The Electoral College was created to enhance the political strength of southern states that had enslaved people. And it didn't matter very much in the 20th century because never in the 20th century did the candidate who lost the popular vote become president of the Electoral College. It happened in 2000 and 2016. It almost happened in 2004 and 2020. And because of population shifts and partisan realignment, it's likely to continue to happen. There's no definition of democracy where it makes sense to say that the candidate who loses the popular vote becomes the president of the United States.
Exciting stuff. But first and briefly, I want to tell you more about the Curious Lawyer series that we have created for you, a true curious lawyer. The Curious Lawyer series is a fun, educational, and entertaining walk down some of the off-the-beaten paths of law, areas that you do not experience in your regular practice day to day, but which are incredibly interesting and informative, and often yield new insights and valuable analogies or metaphors that you can work with in your practice. In this series, We take a variety of interesting issues and intersect them with the law to find fascinating, new, educational, and informative areas of the law to explore, and to better educate you about legal areas you may not know. For example, we have done programs on dog law where you get to think about your favorite furry friend and see how our relationship with dogs intersects the law, from tort to contract law, to even trusts and estate battles over dogs, and, of course, Fourth Amendment cases where there have been warrantless removals of dogs from homes for violating the leash laws. Or you can see the CIA law program, where you will see fascinating legal topics related to the CIA, secrecy, and the Freedom of Information Act, and where you will learn about that famous Hollywood movie line, "I can neither confirm nor deny." You will learn where it came from, and it turns out it was not Hollywood, but you have to watch it to learn who came up with it. We have also looked at whether there's a little sliver of Yellowstone National Park, where, due to a combination of the Sixth Amendment's vicinage requirements and the subsequent federal districts that were created by Congress to sit over the nation, whether that in fact has actually yielded a sliver of land in our famed Yellowstone that is free from federal criminal prosecution. Is it a perfect crime zone? Listen to that program and you will find out. And if you want to brush up on the Bill of Rights, we have a 10-part series with 1 hour devoted to each of the first 10 amendments to the Constitution, so that you, at the next cocktail party, can answer when a non-lawyer asks you what one of the amendments is all about. The one thing the Curious Lawyer series is not is boring. This is most definitely not your typical continuing education. That is often technical, difficult, or stressful. So sit back and grab a cocktail, if you are so inclined, and let's get going in our fascinating, crazy, and at times shocking ethics exploration of our judges. Let's take a look at our agenda today. Here is what we will cover. First, we will look at the Electoral College law of the Constitution. This is from Article 2 of the Constitution and also the 12th Amendment. We will look at and uncover the legal foundation that was set in the Constitution, as well as its evolution over 200 years. Second, we will turn our attention to the Supreme Court and address various Supreme Court cases that have looked at litigation involving the Electoral College. This will take us on an odyssey through litigation at various points from the late 1800s running up to the 2000 election decision of Bush v. Gore. Third, we will address the current law and legal issues that flow from this journey by interviewing and looking at arguments made and addressed by Erwin Chemerinsky in his book, No Democracy Lasts Forever. As an aside, I read it and thought it was a fantastic read and highly recommend it. I learned a lot. It made me think about things I had not focused on, and it certainly made me think deeper about the question of the fragility of our democracy and how close we are to being, as they say, Rome. This exploration, in turn, will let us ask the question of whether the Constitution in this area is working anymore in light of how modern society functions and exists. We will speak with Erwin Chemerinsky and discuss not just the Electoral College, but some other stressors related to it that we are seeing as the Executive and Judiciary battle each other in 2025. Finally, we will do a fun sidebar on secession and the law. We will ask, is secession constitutional? Of course not, you say. But hold on, it may not be as clear as that. We start in the beginning, of course, and that is the Constitution. Now it is reproduced here fully for you. That is Article 2. But we are not going to read the whole thing here and now. The language in red is what I want us to focus on for our educational program today, for us to define and unpackage what the Electoral College is. Each state shall appoint, in such manner as the legislature thereof may direct, a number of electors equal to the whole number of senators and representatives to which the state may be entitled in the Congress. So there you see a delegation to states to appoint electors. And further down you see that once the electors meet and vote, they shall sign and certify and transmit sealed to the seat of the government of the United States, directed to the President of the Senate. And the person having the greatest number of votes shall be the President. So that is the main language for now. And what does this mean in practical legal terms? The point here, it is a deep grant of power to states. Recall the language says, quote, in such manner as the legislature thereof may direct, end quote. How broad is it? We will get to that soon as we look at case law. But first, let's finish our walk through black-letter law from the Constitution. Okay, back to the Constitution. And we will continue along with the red language that gets at the Electoral College and how it works. If the electors vote, that is, the Electoral College vote count, leaves no majority winner, it says. Quote, and if no person have a majority, then from the 5 highest on the list, the said House shall in like manner choose the President. End quote. And no, I did not leave a typo there. That is how the word choose was spelled at the founding. Finally, for our purposes today, the actual time of when all this happens is set by Congress. The Congress may determine the time of choosing the electors and the day on which they shall give their votes, which day shall be the same throughout the United States. That's a lot and it is dense, so let's break it down a bit. Here is the summary. First, this is not a direct vote for president. Each state gets electors at level of Congress representation in the House and Senate. Second, there are 538 electors drawn from the states in D.C., and they do the actual technical vote. It requires 270 to win. Third, each state has a certain number of electors corresponding to House membership along with senators. Let's pause there, as you can see already where this creates room for issues. Let's compare what this means for Wyoming and California. Wyoming has a population of 581,000 odd people as of around 2024 and has 3 electoral votes, 2 for its senators and 1 for its 1 House member. So this means that each Wyoming elector represents roughly 194,000 voters. Now let's look at California. It has a population of 39 million roughly, and it has 55 electoral votes. So each elector represents roughly 709,624 voters. As Erwin Chemerinsky notes in his book, as a result of this math, quote, a presidential vote in Wyoming is worth 3.7 times more than a vote in California, end quote. This is where we see friction in the functioning of the system today, which we will get to in more detail soon. Moving along without overview. Fourth, if no one gets 270, then House of Representatives decides. Fifth, it is not a deliberative body, that is, the Electoral College does not get together and debate. Next, electors are essentially appointed to vote winners mechanistically by state law. Thus, they get together post-election and vote the way their state voted. In 48 states, there is a winner-take-all structure for states' electoral votes. And in Maine and Nebraska, they assign electors with a proportional vote system. Finally, the popular vote across the nation does not always translate to electoral vote, and this leads to historical and modern collisions. We have some listed here for you. In 2016, President Trump wins electoral but loses popular vote. In 2000, President Bush wins electoral but loses popular vote. In 1888, Cleveland secures more votes, Harrison gets electoral vote and wins. And in 1876, Tilden secured 3% more popular vote and majority, but Hayes wins electoral vote. Finally, in 1824, Jackson wins plurality, but House gives it to Adams. These are the 5 instances in our history where the largest popular vote winner has not won the presidency. And note the data, 5 times in history. But 2 of the 5 are in only the first 2 decades of the 21st century. And those 2 instances come after an entire 20th century with no issues. How did we end up with such an odd system as compared to a straight-up vote? Let's go back in time to answer that. Let's start then with the founding time. At the founding, no country on earth had a system of direct vote for a leader. Thus, this was a new issue the founders addressed. That is a huge fact and may be surprising to some when you stop and think about it, given our fluency in voting day in day out, either formally or even informally, where it is. Just majority wins. Thus, the debate at the Constitutional Convention was between either popular vote of people or vote of Congress for the presidency. This debate split the founders. On the one hand, there was distrust of a powerful executive, of course, given the revolution and experience at the hands of the King of England. On the other hand, there was also a fear of congressional corruption also present, and how the few elected and powerful politicians could co-opt the system if they had all the control. Thus, the Electoral College system was a complete compromise, itself a somewhat undesirable deal at the time. No one loved it. No one hated it deeply. It is sort of a classic settlement between competing people where everyone leaves somewhat unhappy and leaves able also to live with it. As part of this compromise deal, states were left to decide their way of choosing the electors. And a winner-take-all rule in states took root fairly quickly and was the subject of criticism from the early days. Let's now listen to more of our interview on these legal issues.
This raises a fascinating point, and that is that you identify in your book this break between the electoral and popular vote that happened 3 times in the 1800s. It never happened in the 20th century, and now in just the first quarter of the 21st century, it's happened twice. Why do you think that we went from this ability to manage the electoral college system within our country for the entire 20th century, but now in the early part of the 21st century, we're seeing such breaks?
As I alluded to, there have been population shifts and there's been partisan realignment. There has been a movement of individuals to states like California and New York, Illinois, and Texas. So let's take the difference between the largest state in population and the smallest state in population. At the time the Constitution was written, it was 12-1. Now the difference between California and Wyoming is 68-1. But Wyoming gets 3 electoral votes by virtue of 2 senators and 1 representative, so it has disproportionate influence relative to California. So the smaller states have more influence in the Electoral College because the larger states' electoral votes hasn't increased proportionally. Some of it is that the House of Representatives hasn't increased in size. Some of it is the 2 senators per state. At the same time, we've had partisan realignment, that the country didn't used to correspond nearly as it does now to ideology. There were southern states that were Democrats. There were moderate Republicans. But when you have the partisan realignment together with the population shifts, we have what we saw in 2000, 2016, and almost saw in 2004. If John Kerry had won Ohio, he would have been president despite losing the popular vote. And if 42,000 votes had been different in 2020, in just 3 states, and that's less than the number of people who fit into a football stadium, Trump would have been president despite losing the popular vote by 7 million votes.
You mentioned sort of the founders in Hamilton, and this sort of this difficult compromise that was made at the founding of the Republic, and this sort of compromise between direct vote, congressional vote, and the rationale for it. Do the fears and the issues that animated the founders in those debates at that time, do those fears and concerns really apply today when we look at the United States today?
Some yes, and some no. I think the fear of accumulation of power, if there's not checks and balances, certainly resonates today. James Madison in Federalist Number 10 said, the accumulation of all powers, legislative, executive, and judicial, in the same hands is the very definition of tyranny. On the other hand, the loss of faith in the people, the distrust of democracy doesn't resonate today. I mean, in 1787, white male property owners were often the only people who could vote. The framers created a government where only one of the 4 institutions that they established was chosen by the people. The Senate was chosen by state legislatures until the 20th century. The president is chosen by Electoral College. Supreme Court justices and federal judges are chosen by the president, approved by the Senate. Only the House of Representatives was meant to be representative of the people.
We will come back to more of the interview as we move along, but first, who exactly are these 538 electors? The Constitution. Article 2, Section 1, Clause 2, provides that no senator or representative or person holding an office of trust or profit under the United States shall be appointed an elector. Now the 14th Amendment says, state officials who have engaged in insurrection or rebellion against the United States or given aid and comfort to its enemies are disqualified from serving as electors. States in turn set some standards. Number 1, political parties choose slates of potential electors before the general election. State process by state party approach. The result is that each party has a set of electors, often people chosen based on loyalty to party, state officials within party, or connection to party's candidate. That is, connected folks within political parties. Not me, that is. And point 2, during the general election, the voters in each state select their state's electors by casting their ballots for the chosen candidate. The winning candidate by vote means those electors are chosen. No, we are not going to read it. But it was passed to address an early problem with the Electoral College. You have it here and in your materials if you want to study it. The key points I will summarize for you in terms of its purpose and what it did. Fundamentally, the 12th Amendment eliminated problems from most ties and deadlocks that emerged in the 1800s. How? The 12th Amendment altered the Electoral College system. For the electors, a distinct vote had to be taken for the president and the vice president. If no presidential candidate has a majority, or if it is a tie, then the House of Representatives chooses the president. Elections, such as those in 1948, 1968, and 2000, would potentially have led to the candidates being decided in the House of Representatives. But the 12th Amendment prevented that from happening since the 1824 election. Thus it is long and dense, but it addressed early problems. What went wrong in 1824 with the Electoral College system? This takes us to Andrew Jackson. Specifically, in the 1824 election, Andrew Jackson won a plurality of the national popular vote and 99 votes in the Electoral College. But that was 32 short of a majority. John Quincy Adams was runner-up with 85, and Treasury Secretary William Crawford had 41. Speaker of the House Henry Clay had 37. But the 12th Amendment required the House to consider only the top 3 vote-getters when no one commands an overall majority. The House chose Adams over Jackson. Adams, in turn, made Clay Secretary of State. And so you can see where this is going. Jackson remarked at this runner-up getting the presidency with the last-placed person joining the ticket, quote, "The Judas of the West has closed the contract and will receive the 30 pieces of silver. Was there ever witnessed such a bare-faced corruption in any country before?" Let's now turn to the Supreme Court cases, and there are not many. Let's start with McPherson v. Blacker in 1892. This involved a Michigan state law that divided the state into separate congressional districts and awarded one of the state's electoral votes to the winner of each district. This was challenged, and it required the court to address the relevant part of the Constitution. The manner of the appointment of electors directed by the Act of Michigan is the election of an elector and an alternate elector in each of the 12 congressional districts into which the state of Michigan is divided, and of an elector and an alternate elector at large in each of 2 districts defined by the Act. It is insisted that it was not competent for the legislature to direct this manner of appointment because the state is to appoint as a body politic and corporate, and so must act as a unit, and cannot delegate the authority to subdivisions created for the purpose. And it is argued that the appointment of electors by districts is not an appointment by the state, because all its citizens otherwise qualified are not permitted to vote for all the presidential electors. And thus the court unanimously held the Michigan law valid and ruled that states can decide their own mechanism for electing electors. That is, and critically, state has plenary power. From 1892, let's fast forward to 1952. This brings us to the case of Ray v. Blair. The question in this case was whether an Alabama state law that requires electors to pledge loyalty in their vote to the party was lawful. Here is what the court said. As is well known, political parties in the modern sense were not born with the Republic. They were created by necessity, by the need to organize the rapidly increasing population scattered over our land, so as to coordinate efforts to secure needed legislation and oppose that deemed undesirable. Further, the requirement of a pledge from the candidate participating in primaries to support the nominee is not unusual. Such a provision protects a party from intrusion by those with adverse political principles. From here, the court, and again this was unanimous, held that where a state authorizes a political party to choose its nominees for presidential electors in a state-controlled party primary election and to fix the qualifications for the candidates, it is not violative of the federal Constitution for the party to require the candidates for the office of presidential elector to take a pledge to support the nominees of the party's national convention for president and vice president. Let's pause for a second on some federal codified law from Congress. Congress has said that when the states do their plenary power thing and certify, that certificate of ascertainment of appointment of electors shall be treated as conclusive in Congress with respect to the determination of electors appointed by the state. This is Title III, USC Section 5C1. And this will play a role in our Bush v. Gore case that we will now turn to. Now we bounce forward again another half century, and this brings us to the year 2000 and the case of Bush versus Gore and the contested election of 2000. So let's recall the facts. Florida certified the state count for Bush per state law. In litigation by Gore, the Florida Supreme Court ordered that the Circuit Court in Leon County tabulate by hand 9,000 contested ballots. It also ordered that every county in Florida must immediately begin manually recounting all undervotes. Undervotes meant ballots, which did not indicate a vote for president, because there were enough contested ballots to place the outcome of the election in doubt. Bush appeals the Florida State Supreme Court recount, ruling under state law, to the United States Supreme Court. Bush's argument was that the Florida Supreme Court violated Article 2 by making election law, which only a state legislature may do. This narrowly is a question of a state court versus state legislature issue. At root, what does Florida state law mean and who gets to decide? When the Florida Supreme Court says that its law requires a certain method of recounting, does it control, or has its interpretation created new law outside Article 2? The United States Supreme Court articulated this rule first. History has now favored the voter, and in each of the several states, the citizens themselves vote for presidential electors. The recount process, in its features here described, is inconsistent with the minimum procedures necessary to protect the fundamental right of each voter in the special instance of a statewide recount under the authority of a single state judicial officer. How would the state court's interpretation of state law stand given the plenary grant of power to the states? Let's listen to part of the oral argument before the Supreme Court and see how the issues were framed and the argument went before we answer these questions. We will start with a question by Justice Kennedy and the argument of Ted Olson arguing for President Bush on the issue of jurisdiction. And then you will hear the same question to David Boies representing Al Gore.
Could we begin with jurisdiction first? The Supreme Court of Florida said that it was cognizant, and the legislature was cognizant of 3 USC Section 5. And for convenience sake, let's call that new law. That's not exactly the same, but when the Supreme Court used that word, I assume it used it in a legal sense. Cognizance means to take jurisdiction of, to take authoritative notice. Why doesn't that constitute an acceptance by the Supreme Court of the proposition that 3 USC Section 5 must be interpreted in this case?
I think, Your Honor, and obviously this court and the Florida Supreme Court is the best interpreter of that opinion. But I think a reasonable interpretation of that opinion is to say that what the Florida Supreme Court meant by cognizant is that it was taking into account the desire to get the election over in time so that everyone would have the advantage of the safe harbor. Well, I think that goes throughout the opinion.
The language used in 3 USC Section 5 is a garden variety language so far as the courts are concerned. We can determine whether or not there is a new law or an old law. That's completely susceptible of judicial interpretation, is it not?
Yes, I think it is, Your Honor.
All right. And it seems to me that if the Florida court and presumably the Florida legislature have acted with reference to 3 USC Section 5, that it presents now a federal question for us to determine whether or not there is or is not a new law by reason of the various Florida Supreme Court decisions.
Except, Your Honor, what the Florida Supreme Court did, I think, in its opinion, is to say that in terms of looking at how to remedy the situation, it needed to be cognizant of the fact that there was this federal deadline out there that was going to affect Florida's electors if that deadline was not met.
Well, of course, the deadline is meaningless if there's a new law involved. And that's part of the equation, too.
Yes, but what I would say is that whether or not there is a new law, that is, whether there's a change in the enactment in the language of the statute or the Constitution, is something that has to be decided in the initial instance, by the Florida Supreme Court interpreting Florida law.
There are really Mr. Boies, there are really two parts to that sentence of Section 5 we're talking about. One is the law in effect at the time, and the other is finally determined 6 days before the date for choosing the electors. Do you think the Florida court meant to acknowledge, it seems to me since it's cited generally, it must have acknowledged both of those provisions?
I don't know exactly what was in the Florida Supreme Court's mind, but I think that in general, what the Florida Supreme Court made quite clear is that the thing that was constraining it was the desire to fit its remedy within the safe harbor provision.
So that's the finally determined portion of Section 5.
Yes, I think that's right. And I think it does not reflect a desire to change the law or in any way affect what the substantive law is.
Our federal jurisdiction. Where's the federal question here?
The federal question arises out of the fact that the Florida Supreme Court was violating Article 2, Section 1 of the Constitution, and it was conducting itself in violation of Section 5 of Title 3 of federal law.
On the first, it seems to me essential to the Republican theory of government that the constitutions of the United States and the states are the basic charter. And to say that the legislature of the state is unmoored from its own constitution and it can't use its courts and it can't use its executive agency, even you, your side, concedes it can use the state agency, seems to me a holding which has grave implications for our Republican theory of government.
Justice Kennedy, the Constitution specifically vested the authority to determine the manner of the appointment of the electors in state legislatures. Legislatures, of course, can use the executive branch in the state, and it may use, in its discretion, the judicial branch.
And why didn't it do that here?
It did not do that here because it did not specify. It did use the executive branch. In fact, it vested considerable authority in the Secretary of State, designating the Secretary of State as the chief elections official. And as we point out, the very first provision in the Election Code requires the Secretary of State to assure uniformity and consistency in the application and enforcement of the election law. The Secretary of State, as the executive branch, is also given considerable other responsibilities. And to a certain extent, especially in connection with the contest phase of the election, certain authority was explicitly vested in the circuit court of the state of Florida, which is the trial court.
But you think then there's no appellate review in the Supreme Court of what a circuit court does?
Certainly the legislature did not have to provide appellate review.
Well, but it seemed apparently to just include selection of electors in the general election law provisions. It assumed that they'd all be lumped in together somehow. They didn't break it out.
Well, there is a breakout with respect to various aspects of Florida statute and Florida election law. There's a specific grant of authority to the circuit courts. There's no reference to an appellate jurisdiction. It may not be the most powerful argument we bring to this court.
I think that
And so the recount as ordered by the state Supreme Court, given its interpretation of its state law, was stopped as violation of equal protection, and no recount could be done in the prescribed time period to certify. It ruled, quote, "The question before the court is not whether local entities, in the exercise of their expertise, may develop different systems for implementing elections. Instead, we are presented with a situation where a state court with the power to assure uniformity has ordered a statewide recount with minimal procedural safeguards." End quote. As a useful note for our education here, the Bush v. Gore court cited McPherson again over a century later for the proposition that states get to decide elector process. Quote, "The individual citizen has no federal constitutional right to vote for electors for the President of the United States." End quote. But this was not unanimous. Let us begin with the concurrences. Justices Thomas, Scalia, and Rehnquist believed that If we are to respect the legislature's Article 2 powers, therefore, we must ensure that post-election state court actions do not frustrate the legislative desire to attain the safe harbor provided by Section 5. In other words, the Florida Supreme Court ruling had tripped state election law structure and Section 5's conclusivity principle. That is, the Supreme said the state Supreme Court misread and applies its own state law. The 5-4 decision had dissenters, and here is 4 on the other side and how they saw the Electoral College question as posed. The Constitution assigns to the states the primary responsibility for determining the manner of selecting the presidential electors. When questions arise about the meaning of state laws, including election laws, it is our settled practice to accept the opinions of the highest courts of the states as providing the final answers. In other words, the state Supreme Court of Florida is best able to say what Florida law requires and dictates. Perhaps the best crystallization of the issue was written, up by Justice Ginsburg. She wrote, "The Chief Justice acknowledges that provisions of Florida's election code may well admit of more than one interpretation. But instead of respecting the state high court's province to say what the state's election code means, the Chief Justice maintains that Florida's Supreme Court has veered so far from the ordinary practice of judicial review that what it did cannot properly be called judging." Their construction coincides with the view of one of Florida's 7 Supreme Court justices. I might join the Chief Justice were it my commission to interpret Florida law. But disagreement with the Florida court's interpretation of its own state's law does not warrant the conclusion that the justices of that court have legislated. This brings us back to our interview.
Now, you mentioned in the 21st century, we've had the 2 examples of the disconnect between the electoral and popular vote. And you just mentioned in these other 2 elections, very, very small numbers of people could have swung it the other way. And so I'm wondering, your book also talks about Bush v. Gore and where Bush v. Gore fits into this question as to whether we have sort of this electoral college problem that Bush v. Gore is a part of, or is it just sort of a standalone separate issue that's not really part of this map you're talking about?
Bush v. Gore is important entirely because of the Electoral College. There's no doubt that Al Gore won the national popular vote, but the outcome of the Electoral College turned on one state, Florida, and we don't have an electoral system that's precise enough to deal with an election as close as occurred in Florida in 2000. And so what happened in the context of Bush v. Gore was on a Friday night, a judge in the Florida Supreme Court said, we should count all the uncounted votes in the state. They assigned a judge, Terry Lewis, to oversee the counting of the votes. On Tuesday night, the Supreme Court said, we're halting the counting of votes. And that meant that George W. Bush won Florida by about 500 votes, carried the Electoral College, with Florida being the decisive margin.
2 decades later, the Supreme Court again had a significant case. Here the case was as follows. Washington state law requires nominees for electors to pledge to vote for the candidate of their party, and any nominee who does not vote for their party candidate is subject to a fine of up to $1,000. 2 electors for the Democratic Party refused to vote for Clinton and voted for Colin Powell. They were fined. The issue then was whether a state law that requires presidential electors to vote the way state law directs, or else be subject to a fine, violate the electors' First Amendment rights. In a unanimous ruling, the court said no. The holding was that Article 2, Section 1, gives the states the authority to appoint electors in such manner as the legislature thereof may direct, which is hyperbroad. Given the breadth of the appointment power, nothing in the Constitution prohibits states from taking away the discretion of presidential electors' discretion. The growing litigation over elections and electoral and popular disconnect that has happened in 2 of the 6 elections as of 2024, given only 3 others in the preceding 220-odd years, has itself spawned controversy and led to modern world and reform movements. Let's look at some of them. First, a framing point. Over the last 200 years, there have been over 700 proposals introduced to Congress to reform or eliminate it. Dissatisfaction with the electoral compromise has been present since the founding. The ideas vary. One says, asterisk eliminate winner. Take all rules and have proportional structures to spread a state's electoral college votes, either by state laws or constitutional amendment. Another seeks a constitutional amendment to require straight popular vote. Here is the National Popular Vote Plan from Maryland in 2007. Its vision is an interstate agreement between states to appoint their electors for the winner of the national popular vote rather than the winner in each state. The idea here is to eliminate wrong winners and assign electors by the deferential state law to the popular vote winner. This is sort of a backdoor way to, by state law, make the Electoral College mirror popular vote. 12 states support it thus far. Stay tuned there then, and this us back to our interview on how the Constitution is working.
Now, as well as the Electoral College, your book, of course, talks about other issues that are causing breaks within our democracy. Could you maybe just flag some of those for our listeners?
I've already alluded to one, 2 senators per state. I recognize that this was an essential compromise at the Constitutional Convention. The large states wanted all representation in Congress to be allocated population. The small states wanted equal representation to the large states. So the compromise was that be the Senate, where every state gets 2 senators, and the House of Representatives, where representation was allocated by population. Well, in 1787, when the difference between the largest state and the smallest state was 12-1, 2 senators per state was something of concern. But now when you have California with 68 times more people than Wyoming, and each get 2 senators, it makes no sense. Let me put it another way. In the first 2 years of the Biden presidency, there were 50 Democratic senators and 50 Republican senators. The 50 Democratic senators represented 42 million more people than the 50 Republican senators. There isn't any way to reconcile that with any definition of democracy.
Your book makes a powerful argument that ultimately, for a variety of reasons, we should sit down and have a national conversation, sort of a mediation, so to speak, as lawyers may say, right? This call for a new constitutional convention to address the Electoral College, the filibuster, Citizens United, a whole bunch of issues you flag. If you had to make an educated guess, sitting here, in the early part of 2025, what seems more likely to you, given the way the Constitution is currently working, that we will get to a constitutional convention to address these breaks in our democracy, an eventual secession of a state, or just this continued status quo inertia where democracy chips away?
Let me be clear, I also argue in the book that there are many things that can be done by statute without needing a constitutional amendment and without a constitutional convention. Congress could pass a law that says that every state has to allocate its electors proportion of the popular vote in the state. That would make it much less likely that the loser of the popular vote could become president of the United States. I think the Senate could change the rules with regard to the filibuster to make Congress operate more efficiently. I think there are things that can be done by statute to overcome some of the Supreme Court decisions that undermine democracy, like a new Voting Rights Act. We forget that the House of Representatives, in the first 2 years of the Biden presidency, twice passed laws to expand voting rights and overcome some of the Supreme Court decisions, only to die in the Senate because of Republican filibuster. I believe that someday there will be a constitutional convention. I believe that someday there will be a new constitution for this country. No constitution lasts forever. The more the Supreme Court says that the meaning of the Constitution today is limited to what was thought in 1787, the more absurd it becomes to be governed in 2025 by a document written in 1787. I don't think there's going to be a constitutional convention in my lifetime. I don't think there's going to be a constitution in my lifetime. But when I wrote the book, I wanted to start the discussion. At the moment, relatively early in the Trump presidency, we're seeing an unprecedented assault on constitutional democracy. This has to be the focus now. It's not the time to try to think about writing a new constitution, but there is going to be that point. And what I was saying is we should carefully plan for it and think it through.
So we have seen the cases, the Constitution, and interview segments, and let us now give you the arguments on each side as we distill them. The arguments for the Electoral College and the arguments against. For the Electoral College to remain side, here are some of the major arguments. State-based federalism that guarantees presidents have nationwide support as opposed to large population centers controlling. No one region has 270 electoral votes, so to win there must be broad support across regions. It encourages stability by encouraging a two-party system, and it augments minority representation by allowing small minority votes in. A given state can make the difference between all the state votes going one way or the other. Now, on the other side of the ledger, some of the arguments against the Electoral College remaining are as follows. Most states are spectators to election. It decreases voter turnout and campaigning in non-swing states. It allows for the minority president risk. That is the one who gets the minority of votes. It hinges on a few states, polarizes elections. And fundamentally, it fails to accurately gauge national will. That is it on the pros and cons. Other nuanced arguments exist that riff on these, but that gives you the overview. Now, as we hear about all this discontent, let's do a quick sidebar on secession. Can states secede? Can they do it perhaps unhappy with this very electoral system we are talking about today? Or for other reasons? This brings us to another sidebar on secession. Here we interview Erwin Chemerinsky on the legality of it, as we assess an old Supreme Court case that passed on it. And if you want a really deep dive into secession, I have done a whole program on it. You can watch that addresses the case law and legal arguments in more detail. But this is a quick aside as we assess the impact of stress on a democracy.
Now, as a quick sidebar, your book talks about secession, and your book made the brilliant legal argument that this idea of secession that's always just been assumed to be obviously unconstitutional, your book notes that it's actually not that clear. Could you explain that and unpackage it for us?
I want to be clear that I am not advocating secession. On the other hand, the question you asked me a moment ago is what happens. And it's certainly possible that we will drift to or move quickly to authoritarianism. I never imagined that I'd be so afraid for the future of democracy as I am at this moment. But I also believe if we continue on the current path, there will be talk of secession. There is an effort to get on the California ballot an initiative with regard to secession. And the more the president and Congress govern in a very far right direction, the more states like California and Washington, Oregon, in New York and Illinois are going to ask the question, is what unites us still greater than what divides us? And so with regard to your specific question, the Constitution is silent about secession. Was that because they didn't want to create a mechanism for undoing what they were creating? Was it because they just didn't contemplate it? We'll never know. There is one Supreme Court case, and it's Texas versus White, and it's often cited for the proposition that secession is impossible. But if you actually read the language of Texas versus White, it says that secession is possible with consent. Now, what consent would be needed and from whom, we don't know. But Texas versus White leaves open the possibility. And of course, the Constitution was written to replace the Articles of Confederation and done in a way that was entirely illegal at the time. Even if there's not a mechanism for secession, there's the possibility. I think it would be disastrous to happen, but that may be the path that we're on if we continue down this road.
Electoral college, filibuster, number of representatives and senators, all of these are legal issues that sit in conjunction with the Electoral College discussion as it relates to breaks in a democracy. Now, we will continue our interview on current events as of 2025 and the interplay between the executive and judiciary, and what this may portend for additional stress on democracy and ultimately the Electoral College system.
Now, given the title and the thesis of your book, and your book came out before last year's election, how do you see what's unfolded in the first few months of the new administration impacting your thesis? And really specifically, if you could point us to certain events that have happened that most concern you about seeing our country slide away from democracy.
The manuscript of the book was completed in the summer of 2023. I chose the title No Democracy Lasts Forever in September of 2023. And yet, right now, it feels prescient to me. So much has happened since January 20th that makes me concerned for democracy. there are all of the executive orders that are just blatantly unconstitutional. The president refusing to spend money appropriated by Congress, which undermines separation of powers and violates the Impoundment Control Act. The president claiming the ability to fire anyone in the executive branch, even when there are federal statutes, including civil service, that limit it. The president trying by executive order to eliminate birthright citizenship, even though it's provided in the Constitution. The president by executive order naming law firms and punishing them for the clients that they represented. The president in blatantly illegal ways freezing money to colleges and universities. And I've listed just some of them, coupled with the president and the vice president suggesting that they may defy court orders. There's some indication they've already been defying some court orders. And Donald Trump said, he who saves the country violates no law. J.D. Vance said, the president doesn't have to comply with court orders for legitimate presidential actions. All of this makes me fearful at the moment for the future of democracy.
We saw some comments from, I believe, the vice president and others in the administration that spoke about the role of the courts and really called for a limit on the federal judiciary's power to enjoin the executive. And I wonder, do you think this may percolate up to the Supreme Court and force it to revisit even Marbury and the scope of Marbury and the scope of judicial power to restrain the executive?
Marbury versus Madison in 1803 said it is emphatically the power and duty of the judicial department to say what the law is. Marbury versus Madison said that the courts get to review the constitutionality of executive actions. I don't see the Supreme Court backing away from that. But the question is, what happens if the president and the Trump administration choose to defy court orders? Courts are limited in their ability to enforce their orders. Courts can use criminal contempt, but that has to be prosecuted by the Justice Department, and the president can pardon. Courts can use civil contempt, though neither of these against the president, but even if civil contempt leads to a jail sentence until the person complies with the court order, that's enforced by the United States Marshals within the Justice Department. So if the Trump administration says, courts, nice that you said that, we're going to continue to do what we want and we're going to ignore court orders, then the president will have the power to violate the Constitution and laws, ignore court orders, and then truly the president can do anything the president wants. And the word for that is a dictator.
Time in American history where we have had such a crisis as between the executive and the courts, where the functioning of sort of our democracy has ultimately required the courts to be the check on the executive because the Congress isn't there to do it. I mean, is there an example that stands out to you that's this serious?
No, I mean, there are examples that people point to. Everyone likes to quote Andrew Jackson saying, John Marshall made his ruling, let him enforce it. Andrew Jackson actually never said that. It was attributed to Andrew Jackson 20 years after he died, and it was relative to a Supreme Court case, Worcester versus George in 1837, which didn't involve an order to Andrew Jackson at all. There's certainly argument that Abraham Lincoln early in the Civil War was defying court orders, but there's also a good deal of scholarship that he wasn't. Franklin Roosevelt in the New Deal posed enormous amount of legislation very quickly. That's the closest analog to Donald Trump's flurry of executive orders, but there's a huge difference. Roosevelt did it by proposing legislation that Congress adopted, and then the courts were declaring unconstitutional. Roosevelt never defied or suggested defying court orders. Maybe the closest you can come is some of the things that Richard Nixon was doing. Nixon was repeatedly impounding funds, but the courts declared it unconstitutional as violating separation of powers. Nixon didn't defy the court order. The Supreme Court ordered Richard Nixon to produce the Watergate tapes. He did so even though it meant the end of his presidency. So the idea of a president defying court orders is really unprecedented in American history.
We've seen the president issue tweets, I believe, or other social media commentary, arguing that judges should be impeached. And then we saw in March of 2025, Chief Justice Roberts issue a statement from the court, not within the context of an opinion of a case, but just sort of a press release, for lack of a better word, I guess. I mean, is there an example like that in history that you're aware of where the chief the chief of the judicial branch has issued a public reprimand or statement towards another branch of government? And if not, I mean, does that itself show that we are in a crisis at this point?
I can think of no instance where anything like that has ever happened in American history. Chief Justice Roberts, somebody who's by nature quite conservative, and I think would be very reticent to put himself out, but he felt the need following the president's tweet and the impeachment resolution to say, in this country, we have never impeached a judge because we disagree with the rulings of that judge. And I do think it's significant that he felt the need to make that statement.
The whole topic, Dean Chemerinsky, really is heavy and hard. And I am curious, given the nature of the topic about having to confront our Constitution, the questions about democracy dying, from a big picture, what was it like internalizing this topic and writing the book? What was that sort of from an emotional, sort of psychological perspective, having to address these issues?
It was the hardest book that I've ever written. I stopped at many points along the way. And the honest answer as to why is I found it much easier to identify the problem than to come up with solutions. And so I always want to be hopeful. I'm an optimist by nature. And I found it challenging here seeing the problems of democracy to come up with proposals and in the end be hopeful.
Thank you very much. And thank you very much for being with us here today.
Thank you so much. Such a pleasure to talk with you.
There you have the interview and the points made as it relates to the Electoral College and the larger arguable breakdown in terms of how it functions for our democracy, as well as the legality or not of secession, as well as the other legal issues that are confronting the courts currently that are stretching the country's legal system. The other side to this equation, however, is that the federal courts have waded into very contentious issues historically. Indeed, the most contentious, social, and political and policy-based issues we have. And their word has been final, and it has been respected by the system as a whole, which argues in favor of the idea that our system is working well, even if it is tested at times. The judiciary says what the law is, and that is foundational, and that precept has no reason to be going away. When the Supreme Court ordered the tapes to be turned over the executive, even though that was the end of his presidency, of course, that is the case of Nixon. And ultimately, it does appear that the federal courts will state what the law is, and the constituents to the system will have to respect it. Perhaps the test right now is more than it has been in the past, but the system has confronted very difficult times in the past, of course, also, and the legal system made it through. The contentious nature of the 2000 election is one example where, notwithstanding the Supreme Court ruling, everyone respected it, and the legal system got on with the business of the country. So let's wrap up our inquiry into the Electoral College and the risk to our democracy that it and other laws may pose. At root, it is important to remember we made a deal out of the gate with the electoral system. Certainly it was an unhappy bargain. Now 28% of 21st century elections as of 2024 have had popular electoral disconnect. That's against 0% in the entire 20th century. Structurally, we learned the law on how it works. The Constitution, 12th Amendment, S&D state laws. We looked at key Supreme Court rulings on the Electoral College. State certification process is near absolute plenary power, we saw. We traced McPherson-Raybush-Chiafalo to see how it works, and how almost always the Electoral College cases are unanimous, except Bush v. Gore. We heard the differing jurisdiction perceptions by listening to the oral argument in part to see how Section 5 worked in the Article 2 Electoral College calculus. Key subpoints to remember. 1. The state has plenary power to create elector system. 2. Loyalty pledges are fine. 3. State certification process that a state court may say is unlawful can be undone by federal courts. We looked also at ultimately the compromises of the Electoral College system and the pros and cons. And we saw many solutions that are on the table either by state compacts or even potentially congressional legislation. We had a great time looking at the challenge to the system by the Electoral College process as explored with Erwin Chemerinsky and his book No Democracy Lasts Forever, and in the interview segments we had with him. Finally, we did a sidebar on secession and constitutionality of it, and we learned it is not as clearly illegal as we may have always thought. Here is one small final thought for you. The fact that we had to do a 1-hour program on the complexity of the voting system to vote for our leader with complex language in the 12th Amendment and Constitution itself may indicate we have an issue that needs correcting. After all, how much legalese should we have in figuring out who is the leader of the country? Thank you for watching, and as always, please email me with any questions.